And I'm honored to welcome Mauricio Rauld, founder and CEO of Premier Law Group, a law firm specializing in private placements. Welcome, Mauricio.
Thanks, Anton. Thanks for having me. It's good to see you and looking forward to it.
Yeah, it's a pleasure to have you on. So why don't you give us a brief background about yourself and your firm?
Oh boy, well, I am an attorney, unfortunately, or maybe not unfortunately. I'm not your typical lawyer, though. Most people, as you know, Anton, most people refer to me as the anti-lawyer, and one of the few attorneys that actually speaks English, which is kind of my little gift. I have the ability to sort of make complex matters simple. But yeah, I've been doing securities work for, what is it now, 22 years now. Started off at a large law firm here in Southern California, and decided that that was not what I wanted to do, but really cut my teeth there, representing some of the big brokerage firms that you know well, Goldman Sachs, JP Morgan's, Merrill Lynch's, American Expresses of the world. But I was doing litigation, so I was always involved in lawsuits, and it was not the nicest environment. And then luckily for me, I'll tell you the quick story, because luckily for me, I came across the Little Purple Book, which I know you've read, and a lot of people, it changed a lot of people's lives, by Robert Kiyosaki, Rich Dad, Poor Dad. That changed my life, really, and that really led me to the Real Estate Guys, which is where I kind of transitioned from the law firm, went to work in-house, their general counsel for the Real Estate Guys, which is where I really cut my teeth on syndication. So I did all the private offerings over there, which were a lot back then. And then I started my own firm in 2006 or 2007, and been doing private placements since then. And today, that's all we do, man. We just bang out PPMs and primarily Reg D offerings, so 506B, 506Cs. We don't really dabble anymore in Reg As. I kind of refer those out. But all we do is real estate syndications, and we do 120, 130, 150 a year, and that's where we're very niche, as you can see. That's all we do is the real estate syndication work. So yeah, happy to talk to you about any of that today, and looking forward to it.
Okay, very good. So you touched briefly on Reg A. What is the reason why you decided that you would kind of refer that out rather than doing it yourself? Because most lawyers say, "Oh, we can do that too," right?
We can do it. It's just a lot more. It's a lot more work. We just realized that our little niche and what we could really bring the most value to was the Reg Ds. We did, probably 3 or 4 Reg As, and it's getting a little bit more and more complicated with the Fed. So the difference between, just really quick, between a Reg A and a Reg D is a Reg A, you have to register it. So it's a little bit less. We have a very specific process. Let me just backtrack. Maybe that we have a very specific process that allows us to do a lot of great things in the Reg D space. It's one of the reasons we do the really fast turnaround speed. We get things done in about a week, which is almost unheard of in the syndication world. But the reason we can do that is a very specific, almost strict process that we go through and that we've created over the last couple of years. With a Reg A, there's so many unknowns, because we start the process very similar to a Reg D, but instead of just saying, okay, we're done, let's give it to the investors, we actually have to submit it to the SEC, and there's an approval process, and there's a lot of back and forth, things they don't like that we have to fix or they want us to add. And so it's about a 6-month process where you're negotiating and going back with the lawyers back and forth. And so it's very difficult to build a very efficient process around there, because you're at the mercy of the attorney at the SEC, government lawyers who may turn around things really quickly, or they may take forever. So it's just hard for us to get that process. And then, with the cost being so high as well, our clientele, they don't want to spend $75,000 or whatever it is going to be to do the legal work and all the compliance work. So most people do Reg Ds anyway, because not many of us have the luxury of waiting 6 to 9 months to get, an offering done. You've got a closing date in 60 or 90 days. You don't have time to wait for the SEC to approve it. So it's just a recent decision. We made this decision, I think at the end of last year, that we weren't doing a ton of them anyway. And so we just decided, hey, let's just focus on what we do best and can really serve the clients the best, which is Reg D. And then, we've got several people that we can refer Reg As, and I'm happy to do that.
Yeah, that's great, right? So again, it's all about expertise in your niche, right? Yeah. And with your expertise, as you said, to turn around in 1 week, that's really extremely fast, right?
It's not easy, but we it's been a challenge. But that's that's there's 2 things that people always complain about. When they come to me from somewhere else, or it's number 1 is turnaround speed. Some people just take 2, 3, 4, and I've heard stories where it just drags on for months and months. And you, as a syndicator, you don't have that time. You've got to, time is money, and you've got a closing, and you've got to get investors in the door, and you run the risk. Investors have a lot of options these days, and if you don't get them in quickly, they might go to the next guy or next gal, next syndication. So that was a big thing for me. I noticed the turnaround speed was something very important to syndicators. And then the other one was just access to lawyers, and I experienced this with other lawyers and CPAs and other professionals, where you're trying to get a hold of them and it takes 2 or 3 days to even get a response, or, you're trying to get a quick meeting and they're just busy for a week or whatever. And so we also have turned that around on its head. Most clients, text me, or my managing partner, Bethany, we're texting constantly and we're hopping on calls. But I hate having to have somebody shoot us an email with a question and for us to take 2 or 3 days to respond, or trying to get a hold of us. So access to lawyers and turnaround speeds are big things for us. And again, it's just based on market feedback. That's just what I've recognized what syndicators want. And we've kind of provided that for them, and it's been working great because of that.
Yeah, that's great to hear, and we see that right. We work with a lot of syndicators that who use different type of lawyers, and that's very often a challenge. Right, get a prompt turnaround, and also once you are in the process to close that deal, if you do not get quick feedback, even on just the lending side, right, it can be very problematic. Right, so it's good to hear that you have that process really under control, right? And obviously, the more you do it, the more comfortable you are to speed up that process.
Yep.
What would you say between 506 Bs and Cs? What do you see? Have you seen a change in trend? I know that a lot of people decided initially it was mostly 506 Bs, right? And then it moved kind of towards 506Cs, but we have seen now more people going back to the 506Bs. Is that something similar what you see, or do you see a different trend?
Yeah, I mean, nationally, if you look at the statistics that the SEC puts out every couple of years or whatever, it's always been pretty surprising to me that not many people are doing 506Cs. I think originally at some point, because I talk about this at my presentations, it was about a 90-10 split nationally. 90% were doing 506Bs and 10% were doing 506Cs between those two. And then recently I saw that number even get more skewed. It was like, I think 93-7 or something like that. So it seems like less and less people are doing 506Cs. Now, in my practice, again, I've got a very niche practice. I represent small mom and pop investors, syndicators. The average raise that I do is probably $2, $3, $4 million. Every so often we'll get a big raise of 8, unlike a lot of these institutions that are obviously raising hundreds of millions, if not billions of dollars. And so I see a little bit more willingness to do the 506Cs. It's going to be an estimate. I don't have actual knowledge. I keep telling myself I should pull the actual numbers, but I'm going to say probably a third of my deals are 506Cs, and then the other 2/3 are Reg Ds. I'm sorry, 506Bs. So we're getting there. And I think I would say that I've seen, as people got more comfortable with it, more and more 506Cs, especially and I think it's a natural progression, as you run out of your friends and family and people in your circle, the next thing that happens is you start trying to hit that gray area of using advertising, but trying not to. And then it gets into that little gray area. And then I think people just realize, hey, look, I've already run out of all of my 506B investors. They're kind of already in my deals. And so let's try the advertising route, which, these days with what you're doing with podcasting, with social media, whether it's YouTube or Facebook or Instagram, and then obviously the live, meetups and all that stuff, there really is almost an unlimited traffic that you can tap into, and it's just a question of being good at it. But so I think 506C, it's definitely becoming more and more relevant, but not, again, mine's a niche. It's not as extensive or as limited as it is in the national, where it's
right
at 93.7, I think was the last statistic I saw.
Yeah. I think also the 506C provides kind of a safety net, right? So you know that when you talk to someone that you're allowed to talk to them. And a lot of people, I think, underestimate the risk that you have with a 506B, right? Yes, you have your relationships. Yes, you think that you only tell your pre-existing relationships about that deal, but it doesn't take much until you talk to someone you shouldn't talk about it.
Yeah, and that happens a lot. I mean, you and I obviously were well, before COVID anyway, we were part of the sort of the circuit. We always run into each other, and it's amazing how many emails I will get from attendees at those seminars that I'm sure I met, but I'm sure we just exchanged cards. I gave them my card as an attorney looking to make relationships there, and then they gave me their card as they're looking for passive investors. And then within a couple of weeks, I'll get an email from them and just pitching me their next deal, and I'm like, I don't know this person from anyone. I don't even remember them. You meet so many people, and yet they're emailing already. So they're not going through that process, which is time consuming, and it's not fun to go. Somebody that you meet, a complete stranger at one of these events, or even on a Facebook Zoom or whatever, that you don't really know, and put them through the 6 to 7 to 8 steps that are out there that the SEC has said. You got to take these steps to then take them from a complete stranger to somebody that you have a substantive relationship with. And most people don't really do that very well, and they certainly don't document it. So I think if any of these, not if any, but if a lot of these syndicators, if something were to go wrong in the future, and an SEC or a state regulator were to ask them, hey, prove to me that you had a substantive relationship, because it is going to be your burden to prove that, they're going to have a hard time pulling up records, because most people don't keep records. They don't keep a copy of the questionnaire, for example, that they should be sending out. They don't keep detailed notes of whatever phone calls or meetings they had. They don't have they don't have the file built up so they can show to a regulator, hey, here are all the things I did back in 5 years ago that I felt was good enough for me to establish that substantive relationship to get to know my investor, and then that's why I offered him a future deal. So 506C I think is safer, but you're limited. You can only, as you can only accept accredited investors, so that's the first limitation. And for some reason, there's a verification requirement, and for some reason, which I'm still not sure why, but a lot of investors, passive investors, especially the high net worth individuals, are a little bit hesitant to provide them with their financial information. Even though they're not really giving it to them, they're using third-party verification companies, so the syndicator actually never sees their financials. They still don't quite understand, and I guess if they're looking at 10 different deals and the other deals don't require them to submit financials, then they might as well, that's kind of an edge that you lose by doing a 506C, but
yeah,
I like it.
Yeah. Yeah. So have you seen some new changes that have come on the horizon? Obviously, last year there was quite a flurry of some new activity of changes of rules that were proposed, and some of them are still in the pipeline. Can you tell us a little bit of what has passed, what is still in the pipeline, and what you see might come or might not come to fruition?
Yeah, I think there was a lot of, as you mentioned, there was a lot of SEC activity last year, and I don't know if it was because sort of the commissioner was on his last year and he just wanted to kind of get stuff done, or with the potential change of administration. A lot of activity came down the pipeline last year, and probably the most well-known, although maybe a little misunderstood, was they finally got to at least start the process of expanding the definition of what an accredited investor looks like. Ever since, I think since 1982 that this has come out, they've always tied accreditation with financials, right? You have to be a high net worth individual, either $1 million in net worth, excluding your primary residence, or you've been earning a couple $100,000 a year and expect to earn, reasonable expectation of earning that this year. So it's always been financial. And as you and I know, Anton, there's plenty of people who have gobs and gobs of money and are the dumbest people in the world, right? We all know those. And there's also, on the flip side, people who are modest means, or maybe not modest, maybe they've got 300, 400, 500 grand, and they're super smart, way smarter than you and me. And so there's always been this debate: is that really the right way to do it? And there's always been this discussion of having some kind of an examination or some kind of test that you might be able to take to show that you're actually sophisticated. And that finally happened. So last year, I think back in November, it became official. They expanded. Let me make sure I phrase this right. They did expand the definition of an accredited investor, but what they said is like, look, there's going to be you're going to be able to get certified as an accredited investor, meaning you're going to be able to go to a course, a seminar, whatever, and then that's going to certify you to pass an exam. You take an exam, pass an exam, and they're going to give you a certification that says, hey, Anton, you passed the exam, you're going to pass it in flying colors, Anton. And so you're going to get certified as an accredited investor, and now you're going to be eligible for things. The challenge was when the rule came out, the SEC still hasn't gotten around to identifying who's going to be, who's going to be certified to give these certifications, right? Right now, we don't have, what institution. We have no idea what it's going to look like. Is this going to be a 3-day weekend seminar? Is it a self-study? Is it a 1-day thing? Is it just an exam? Like we have no idea what any of that looks like. So that's what we're waiting on. And that's going to trickle in. You're going to get an announcement, a press release suddenly that's going to say, hey, this institution has been certified. So if you go take their course, pass their exam, you can get certified. The only thing that for now they brought in immediately was if you were a registered investment advisor. So if you're an investment advisor, you will be now, or as of right now, you are an accredited investor irrespective of your financials. And then if you pass certain exams, specifically a Series 7, a Series 65, and a Series 82, I believe those are the three, then again, that's kind of the exam that you've already taken. So if you have those exams and pass, then you're also an accredited investor. But other than that, it didn't really change a ton, other than it set in motion. It laid the ground and the foundation to come this, although it's already kind of halfway through the year here. But we're expecting something down the pipeline that tells us what institutions we can go to take an exam and what that looks like.
Okay, so you never hear anything from them until they announce it. So it's not like a kind of behind the scene grapevine that trickles some information through.
No, I mean, it always gets done with a press release or some kind of a release that the SEC does. And, you got to think about it. They probably are in the process of putting together what the requirements need to be that are going to be taught in this course. What are the topics that need to be? It's almost like you're putting together an approved curriculum that you can then say, hey, look, if you go and prepare this curriculum, then we're going to certify you. Just like if you're going to a school, right, you want to be certified in a particular curriculum. So I'm sure that's what they're doing, number one. And then going out to, whatever, I'd imagine something like, I don't know if you guys, those of you guys who have taken those sort of SATs or maybe LSATs or MCATs, I mean, I think the company's called Kaplan or something. I mean, any of those, it's going to be something like that where Kaplan might come out and become certified, because that's what they're in the business of teaching.
Sure.
And helping you pass exams. It's going to be those types of institutions that will get that certification process done. But I'm sure that's what they're in the middle of. But we'll get it through a press release, I'm sure.
Yeah. Okay. So that's positive news, right? That once it's being finalized, that definitely will help, and it certainly will help syndicators, right? So now the access to accredited investors certainly will increase. The question then is, okay, so now the financial information sharing, does that still have to take place, or is that completely out the window if you have that accreditation from a Kaplan or whatever it is?
Yeah. And you wouldn't have to rely on any. You could be broke. You could be millions of dollars, and you could have negative net worth. You could be unemployed. But if you've passed your Series 65 or got a certification from Kaplan or whoever's going to get certified, then that's all you need. Right. So I'm sure from a verification standpoint, all you're going to have to require, if you're going to be verifying, is just get a copy, maybe it's a certified copy of that certificate, and then you're good to go.
Yeah.
But right now, just to kind of give you a little bit practical, because that was very vague, obviously, because that's where we're at. I think I'm actually going to write a blog on this, or maybe do a video. But I think the fastest path, if you're not an accredited investor and want to be an accredited investor, is the Series 65 exam. I think that's the easiest of all of them. So you just you study for that probably on your own. You take the Series 65, you pass that, then you register with whatever state you're in, and then you're going to be, you're going to be in good standing and all that stuff, and then you become an accredited. So if you're a passive investor who's kind of really desperate to invest in some of these, accredited only offerings, I would look at the Series 65 exam as your route as it stands right now.
Yeah. Okay. Very good. So that's probably going beyond of what you already know, but does that mean that you have to be also registered with a firm, right? Because with the 65, obviously it's not just that you are on your own, but in order to practice, you would have to register with a firm, right? Similar with on the real estate side, where as a real estate agent, you need to register with a brokerage firm. Is that the same thing with the 65 or the 7?
No, all you need to do is be in good standing in your state. So I do believe there's a registration requirement with the state, but as long as you have a license in good standing, then that's what I've seen, at least on the SEC website, specifically a Series 65. I don't know why, you know this more than I do, what, why that they would specifically single out Series 65s versus the 82 or the 7, but there is on their website, they do specifically, as an example, say, hey, if you've got a 65, it's got to be in good standing and you've got to have it registered in your particular state.
Okay, very interesting.
Yeah.
I think one of the other items that was quite a big topic among syndicators and whoever wanted to be also part of the fundraising activity was the changes to the fundraising.
Yeah.
Do you have any news on that?
Yeah, I don't have any news on that. And actually, we were just talking about this before we went off. I may stop talking about it a little bit because it's been a while now. And, although I did say, second quarter, so I guess we haven't run out of the second quarter yet. But this was a rule that came about, a proposed rule back, I think, in October of last year, or maybe November, but I think it was October. And again, I want to emphasize the word proposed. And so there was, again, a press release and, I don't know, I can't remember how many pages the actual proposed rule was. But essentially, as you know, me and many other lawyers have been hammering the social media stratosphere about this issue of money raisers, right? There are people that are actually out there raising money for syndicators and getting compensated for raising that money, most likely in the form of a share of the GP. And so we've gone through this whole analysis that you generally have to be a broker dealer, which obviously nobody is, or you've got to follow these strict rules. The challenge is, and I think this is what the SEC, I think they specifically recognize this, is that broker dealers, and you know this better than I do, they typically don't like to get out of bed unless they're raising a lot of money, right? So they don't want to it's the same amount of work for them. So they don't want to raise $1 million for you or 5 or maybe even 10. They want to be raising 20, 30, 50, 100, $500 million because they get paid on a percentage basis. So it's very difficult for a small time syndicator who's raising 1, 2, 3, 5 million to get a broker dealer. And so there's a gap that exists right now in that world. And that's why I think a lot of people are kind of getting into that gray area or maybe overstepping the boundaries. So the way they've addressed this is they made this proposed rule, which would then allow people to actually make referrals, make introductions of people they already know to syndicators and get paid a commission, transaction-based compensation, which historically, traditionally, that's the hallmark of broker-dealer stuff. But essentially, just to give you the really high-end, high-level summary, you're going to be, if this were to pass in its current form, you could refer people that's already in your network. You can't go out and advertise and use social media to attract those people. But if people are already in your network and they're accredited, so it's only applicable to accredited, I can then refer that person to a syndicator. I can actually participate somewhat in the process. I can be part of that meeting. I can show my client or whoever I have, I can show them the offering documents. I can walk them through them. I can't make any recommendations, obviously, but I can help explain it to them. I can be fairly involved in that process. And then if that person were to invest in your deal, then I can take a commission from that, right? A 5%, 2%, whatever we negotiate. Now that has to be in writing. That has to be, there has to be a written referral arrangement or whatever, some agreement between me and the syndicator. And of course that needs to be disclosed to the investor that's coming in, that there's this relationship, because as you can imagine, it does affect somebody's thoughts on a particular investment if they know that the person making the referral is going to get paid for that referral. So, but the nice thing is you'll be able to get transaction-based compensation. And so this was really exciting when the proposal came out in November or whenever it came out. The challenge is that because of the transition with the new administration, the SEC commissioner actually resigned a little bit earlier. His term wasn't up until June of this year, but he ended up resigning, announces his resignation last year. There was a new SEC commissioner that just got sworn in a couple months ago, I believe it was. And he's known to be a little bit more, although it's mostly on the Wall Street side, but he's known to be a little bit more of a regulator. And so we just don't know whether there's any appetite now at the SEC that's under new leadership for this kind of stuff, to loosening up these rules, or if the new commissioner is going to take a little bit more hard stance. So this might get tabled until a new commissioner shows up, or maybe we'll hear something, soon. Now, typically it takes 6 months between, 6 to 9. That's why I say 2 to 3 quarters between a proposed rule. Because what happens is a proposed rule comes out and they request comments. So they go out to the community. They say, hey, please give us your feedback. Give me your comments. Here's some questions we have that we're not quite sure. And then they take all those submissions after about a 60-day period, and then they formulate a final rule taking into account all those submissions. So that usually takes 6 to 9 months. In fact, the new rules that we talked about that came effective last November, those had been proposed back in March. So as you can see, it's a good, 6 to 9 months. So I was kind of expecting if something were to happen, it would be happening right around now. Honestly, it's sort of the middle to end of the second quarter, which is kind of where we're at. And who knows? I think it's still there. I don't know I don't have any any updates. Nobody's telling. Nobody. I don't have a direct line to the brains over the SEC, but you can be assured that as soon as it comes out, then we'll all be on social media and YouTube.
Oh, sure,
Facebook,
definitely.
talking about it. Yeah,
absolutely. Yeah. So obviously, that topic of money raising is always a very tricky subject, right? And we have seen, I would say, both of us, we have seen deals where some of the syndicators and GP partners probably were a little bit in the gray zone, to call it lightly, right?
Yeah.
So I think what we also have heard then, well, why don't we just do a JV and we don't have any issues, right?
Yeah.
Which brings up another element, right? That I think a lot of people do not really understand, that you have to follow very specific rules to truly be a joint venture.
Yeah.
And I think you wrote a book about it, or an article about it,
Yeah.
like how to stay out of jail. So maybe you can touch on that a little bit.
Yeah, I wrote a book, it was an ebook last year, called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And the number one thing was just understanding what is a security and what is not a security. And that's probably the biggest mistake most people make. They don't realize they're selling securities, or maybe even worse, they realize it, but they're trying to get around it by creating some kind of a structure. And what's really important to understand is that what you call something is completely irrelevant. You can call something a joint venture, you can call something a syndication, you can call something a loan, or whatever you want to call it, it doesn't matter. The SEC is going to actually look at the actual transaction. And so anytime you take money from a passive investor where the returns are being generated by your efforts, that is a securities offering. You are issuing securities, and it doesn't matter if it's in an LLC or in an LP, or if it's a joint venture, or if it's a profit sharing agreement or a TIC agreement, or it doesn't matter how you structure it. That's the test. Are you taking money from passive folks where the returns are being generated by your efforts or the efforts of the other co-sponsors? And so the same applies to a joint venture. Just because you call something a joint venture doesn't make it so. A lot of people's like, well, I have the choice. Do I make this a securities offering? Or maybe to some extent you have a choice if you change the structure a little bit. But if you have passive investors, if somebody's writing a check and you're doing the work, even if you've got 10 people and only 3 of them aren't really doing anything and the other 7 are, those 3 people are being offered securities because they're passive. And so in order for a joint venture to be a true, legitimate joint venture where it's not a securities offering, where it's outside the regulations of securities, everyone has to be actively involved. Everybody needs to be doing work so that the returns are not being generated by 1 or 2 or 3 people. The returns are being generated collectively by everyone's work. And so as long as that's the case, that's fine. But keep in mind, you can't go crazy. I mean, typically you want to keep those to 5 people or less. I mean, it's very difficult to show that you have a joint venture if you have 10 people in there, right? Or 8 people, because inevitably somebody's not carrying their weight. And then you also want to be careful about, you not putting any capital yourself, but somehow getting, 20 or 30% of the deal when you haven't put any money in. That makes it a little bit tricky too. So in general, you want to keep it to 5 people or less. You don't all have to be co-managing. It's okay to have one person sort of do the day-to-day activities, sort of be the, the president or the chief operating officer, whatever. But any major decisions, you want to make sure every single person is involved. Obviously acquiring or selling or hiring a property manager or getting the financing or deciding to refinance or doing some major remodel. You just want to make sure everybody's there. If it's only 2 or 3 of you, it's probably best to have all 3 of you be co-managers or co-runnings and have everybody sign. And obviously to the extent everybody can be on the loan as well, that helps a ton. But it's very tricky. I know a lot of, another thing I don't really do joint ventures anymore. So I refer those out, but I refer it out to people who kind of know a little bit about securities work. So I'll typically get a call. They'll describe this as a joint venture. I'm like, well, great. Let me refer you to to so-and-so. And then inevitably, a lot of times I'll get a call from that person and be like, hey, this is really a securities offering because there's one person doing all the work. They're taking, I mean, there would never be an acquisition fee or an asset I mean, you wouldn't have that kind of language in a joint venture. A joint venture would just be there's 5 of us it's like you're starting a business. There's 5 of us that are starting a business and we're all contributing capital. We're all contributing something. And then we're splitting the profits, kind of proportionally. When I start seeing acquisition fees and, I'm putting in 10% of the capital or 2% of the capital, but getting 50% of the deal, that starts to look a lot more like a securities offering and not a joint venture.
Yeah, very good point, right? So I've had that discussion a number of times also, right? Though we are only 5, right? And because it's such a small group, it's a joint venture. No, it's not. Right? So just because it's only 3 or 4 or 5 investors, still doesn't make it a joint venture unless it is truly a joint venture.
Yeah.
Right?
You could have one person. You could have one person, be you and one other person, and you could call it a joint venture. But if that person is just writing a check and you're doing all the work and going home, that's going to be a securities offering, unless you can structure it a certain way. Like, look, with one person, it's very easy to get around that. Either structure it as a loan, secured by a first position lien on a lot of flippers do that, or just make everybody a co-manager. So there's only 2 people, but when you get to like, I've got 7 people, but only 4 of us are 3 of us are doing the work and the other 3 or 4 are writing checks and going home. That's going to be again, you can call it whatever you want, but the SEC and the regulators will see that as a securities offering.
Yeah, very good point. So thank you very much, Mauricio. How are our listeners able to get that ebook? And maybe that also brings us to the question: how can they reach you in general? Right, email, social media, whatever it might be.
Yeah, I appreciate it. If they want a copy of the ebook, you can find that at the website of stayoutofjail.com. So if you go to stayoutofjail.com, you'll get be able to download that. And as you know, I'm pretty active on YouTube, so I've got a YouTube channel that I try and provide as much value as I can. And then the website, premierlawgroup.net. You can always reach out to me if you guys want to have a consultation. Always happy to do. I do those myself. And so if you've got questions about a securities offering or just the topic in general, you can swing by the website. There's a little, contact us, and that'll get to me, and we'll put something on the calendar.
Yeah, that's great. Thanks for all the input, Mauricio, and the update. Right, as your wealth of knowledge in that niche, as you call it. Right, so it's always great hearing from someone who is doing it day in, day out. So really appreciate that you have had time to come on today.
No, my pleasure, Anton. It's good to see you as always, my friend.
Yeah, same here.